Welcome to the deep dive. If you've ever wondered about that thin line, between a terrible accident and an actual crime, well, you're in the right place. Today, we're really digging into a fundamental question. When does a death caused by just pure inattention, something completely inadvertent, become a criminal act? Where's that line?
It's a tough boundary, honestly, one of the trickiest in criminal law.
Yeah.
And the Model Penal Code, the MPC, it offers what many see as the most, let's say, rational approach. So for this deep dive, we're going to focus only on the MPC's take on these inadvertent killings. That's negligent homicide, Section 210.4. Our goal here is to really nail down the legal standard for negligently, in this specific context. We'll look at the policy reasons behind it, rationalizing punishment, reducing the grade compared to manslaughter, and then give you a clear framework, something actionable you can use.
Okay, let's unpack that, because understanding this MPC framework, it sounds like it's the shortcut, right? To get the difference between just being careless, maybe facing a lawsuit, civil negligence, and criminal negligence, which, wow, could mean a serious felony charge. Absolutely need to know where that line is. So let's start with the basics, the black letter law.
Mm-hmm.
Can we dive into defining negligence itself? What's the actual rule? What does MPC Section 210.4 explicitly say about negligent homicide?
Right. The general rule itself is pretty concise. It says criminal homicide constitutes negligent homicide when it's committed negligently. That's Section 210.4, Part 1. And then the MPC nails down the severity in Part 2. It's classified explicitly as a felony of the third degree.
A felony 3, just for negligence. Okay, that high grading, it tells me right away we're looking for something much more serious than, everyday carelessness. Let's test this rule. Put it into action with a scenario, maybe something dangerous that really shows what the law means by a gross deviation. Oh, okay, picture this. A construction foreman, let's call him Mr. D. He's overseeing maintenance on this massive, inherently dangerous industrial machine. Now, the safety rules, they're not optional. They're mandatory. Clear as day, highly visible signs everywhere saying lock down the machine before anyone goes near it for maintenance. But Mr. D, he gets caught up in a long personal phone call, completely distracted, and he just forgets, fails to secure the equipment. And the result is tragic. A coworker, thinking it's safe, walks into the machine's path and is killed instantly. Now, here's the critical part for negligence. Mr. D wasn't thinking about the risk while he was on the phone. He genuinely forgot. But the danger, the protocols, they were obvious. Okay, let's analyze this foreman scenario using our structured approach. First things first, what are the legally dispositive facts?
Okay, the key facts are pretty straightforward, and they really focus on that failure of duty. You have the foreman, Mr. D. He failed to follow mandatory, very visible safety rules. He was distracted that phone call. And crucially, he was genuinely inadvertent about the risk, meaning, no subjective awareness of the danger at that moment. But this failure directly caused a death.
Got it. And the core legal issue here?
The issue is whether Mr. D's this inadvertent failure to follow those obvious safety rules leading to a death, whether that meets the standard for criminal negligence required by MPC 210.4, is at that level of negligence.
So what rule did the court actually apply to decide if this crossed the line into a crime?
They applied MPC Section 210.4 directly. It defines the offense simply as criminal homicide committed negligently. So the court had to interpret what negligently means in a criminal apenal context. The focus was really on setting that high bar, the idea of a gross deviation.
Right. The analysis. This is the crucial step, isn't it? How did they take what sounds like forgetting an accident in the everyday sense and elevate it to a felony conviction?
Exactly. The analysis pivots on an objective standard. It's not about what Mr. D was thinking, but whether he should have been aware of a substantial and unjustifiable risk, even if he wasn't consciously thinking about it right then. Now, if he had consciously thought, this is risky, but I want to finish my call, and ignored it, that's different. That would be recklessness, potentially manslaughter. But because he was genuinely inadvertent, the court had to gauge the severity of his lack of awareness. And the MPC standard is clear. The failure must be a gross deviation from the care a reasonable person would take. So, given the rules were mandatory, highly visible, designed specifically to prevent this exact kind of immediate danger, well, the court reasoned his failure wasn't just a slip-up. It showed a shocking, really inexcusable lapse in attention and judgment for someone in his position. It was more than just civil carelessness. It was a blameworthy, gross failure to meet the basic standard of awareness needed for that dangerous job. And that met the criminal negligence threshold.
Okay, that distinction is key. Criminal negligence isn't so much about the actor's inner thoughts, but about how far their conduct strayed from what society expects as a minimum level of safety in that situation. And the conclusion.
The conclusion follows directly. Mr. D is found guilty of negligent homicide, a felony of the third degree.
Wow. That framework really demonstrates how effective and adaptable the MPC's single standard can be. But you mentioned the MPC had bigger goals than just punishing specific acts. It aimed to simplify the whole area of accidental killings. The explanatory note for 210.4 mentions two huge aims: rationalizing negligence, which we've seen, but also replacing specialized statutes. What kind of statutes are we talking about there?
Oh, it was trying to clear up a real tangle of old laws. Historically, different states had all sorts of specific homicide statutes based on how someone was killed, like using a boat or a gun or a vehicle. The explanatory note specifically calls out replacing those specialized laws, primarily the ones dealing with vehicular homicide. The MPC wanted one single, uniform standard for negligence, whether the death resulted from a faulty machine like Mr. D's or from reckless driving.
Okay, let's test that idea of replacing specialized statutes with another scenario, maybe something a bit more visceral. Imagine a driver, let's call her D. She's speeding like crazy, say 95 miles per hour, down a winding residential street, way over the limit. And at the same time, she's trying to eat this really messy, complicated sandwich, right? Takes her eyes completely off the road for maybe 5 whole seconds to deal with the sandwich mess, and boom, fatal head-on collision. Now, before the MPC, a lot of places would have used a specific, maybe confusing law like vehicular manslaughter or vehicular homicide. How does MPC 210.4 handle this differently, and why is that considered an improvement?
Yeah, this is exactly the kind of situation the MPC was designed to streamline. Instead of getting bogged down in the specific, often inconsistent requirements of some old vehicular homicide law, the prosecution just applies the standard 210.4 test. Did the driver fail to perceive a risk she absolutely should have? Yes, clearly. Speeding that excessively on that kind of road, combined with taking your eyes off the road for that long for something so trivial, that's an undeniable gross deviation from the standard of care any reasonable driver would observe. Her conduct, it doesn't matter that a car was involved, showed criminal negligence. The MPC focuses the analysis right where it should be, on the actor's mental state. That gross negligence, not on the specific tool, like the car. It simplifies things enormously.
It really sounds like the MPC cares less about how you killed someone and much, much more about why, about the level of fault in your thinking or lack thereof.
Precisely. It brings a needed rationality and uniformity to this part of the penal code, makes it more consistent.
Okay, now for that second big policy goal you mentioned, the MPC deliberately wanted to make sure that all inadvertent homicides, the ones based on negligence, are graded below manslaughter. So what's the actual functional difference in the required mental state that makes negligent homicide, a felony 3, always lower than manslaughter, which is usually a felony 2?
Right, and this gets to the heart of moral culpability, which really drives the whole MPC grading structure. The key difference is awareness. Manslaughter under the MPC requires recklessness. And recklessness means the person consciously disregarded a known, substantial, and unjustifiable risk. They saw the danger, they knew it was risky, and they went ahead anyway. Negligent homicide, on the other hand, is defined by that inadvertence. The person should have been aware of the risk. A reasonable person definitely would have been, but they weren't. They were essentially blind to the danger because of their inexcusable carelessness.
So the act of consciously deciding to ignore a known danger is seen as inherently more blameworthy, more culpable than failing, even grossly failing to see the danger in the first place.
Exactly. That lack of conscious disregard, even though the carelessness itself is blameworthy, warrants a lower grade in the penal system. Penal sanctions, like a felony 3 conviction, are definitely still seen as necessary to deter that kind of gross carelessness that leads to death. But the absence of that subjective, knowing choice to proceed despite the risk means the actor is considered fundamentally less culpable than someone who acted recklessly. The MPC structure deliberately ensures negligent homicide stays as the lowest grade of criminal homicide for that reason.
That contrast is so critical, isn't it? Recklessness means you knew and did it anyway. Negligence means you should have known but didn't, due to gross deviation. That seems to be the bedrock of homicide culpability under the MPC.
It really is. Okay, so now, let's try to pull all of this together, the rules, the case analysis with Mr. D, the policy goals, into one practical diagnostic checklist, something you can actually use when you're looking at a homicide case and trying to spot the issues around inadvertence. Step 1 is your initial screen. Pretty basic. Is there a criminal homicide? Did the defendant's actions actually cause someone's death? If yes, you move on. Step 2, and this is really the mental state assessment, the critical filter, was the conduct inadvertent? Did the defendant fail to see a substantial risk that they absolutely should have seen? Now, if your analysis shows they did consciously see the risk and disregarded it, you stop right there. That's not negligence. The analysis immediately jumps up the ladder to recklessness, potentially manslaughter. Okay, step three is a negligence standard check. If the conduct was inadvertent, was the failure to perceive the risk bad enough? Was it a gross deviation from the standard of care a reasonable person would have exercised in that same situation? This is what separates ordinary carelessness from criminal negligence. And finally, step four, the application. If you determine the homicide was committed because of this gross inadvertent negligence, then you apply MPC 210.4. And applying that rule tells you two key things instantly. One, it replaces any old specialized negligence laws like those specific vehicular homicide statutes. And two, the grade must be below manslaughter specifically. It's a felony of the third degree.
That framework is incredibly useful. It really lays out how to navigate that complex hierarchy of culpability in homicide cases. And it highlights what you said earlier. The real power of MPC 210.4 is its efficiency. It gives us this single rational standard to apply when death results from inexcusable carelessness, no matter how it happened, machine, car, whatever. It covers a huge range of these inadvertent killings. So stepping back, what does this mean for you, listening? Think about that balance the MPC tries to strike. Considering this clear legal line between negligence and recklessness, does a felony third-degree conviction, which is still a very serious penalty, feel like it adequately reflects how society views the moral blame for causing a death that the actor didn't foresee at all, but any reasonable person would have? It's something worth mulling over, that challenging policy balance. Where exactly should we draw the line between punishment appropriate for the harm caused and acknowledging the reduced moral culpability when someone truly didn't see the danger, even when they absolutely should have?
easy answers.